Florida's highest court hearing arguments over the state's current 15-week abortion ban, which was passed by the legislature and signed by the governor last year.
Lawyers from both sides presented their cases a few hours ago to see whether or not the ban's legal. News 6's Ezzy Castro has more from today's hearing.
HB 5's abortion ban has been in effect now for more than a year, violating fundamental rights.
Attorney Whitney White with the American Civil Liberties Union presenting her case in front of the Florida Supreme Court. She argued on how reproductive rights organizations claim the state's 15-week abortion ban is violating Florida's constitutional right to privacy provision.
In 1980, the right to privacy included a right to decide whether or not to have an abortion up until viability. This court has consistently held in abortion and non-abortion cases alike that the privacy clause, when voters adopted an express and freestanding privacy clause that had no analog under the federal Constitution.
Florida's Solicitor General Henry Whitaker started his opening statement by arguing the Florida Constitution does not provide protections for abortion rights.
We did take a fresh look at this issue. And I think it's fair to say that the kind of historical evidence that we've really done a deep dive into the historical record, and what it shows, I think, is pretty striking about the historical backdrop behind the enactment of the privacy clause.
The state's 15-week abortion ban has been in effect since July 2022. But advocates say women should have the choice to legally get an abortion up to fetal viability of 24 weeks. However, that ruling will be up to the justices, which could happen sometime next month.
Whatever you think about the status of an unborn life at any particular stage of pregnancy, it is a life in some sense, and it is unquestionably extinguished by the abortion decision, and the legislature was entitled to take that into account.
Ezzy Castro, Gonna Results, News 6.